Welcome back, ladies and gentlemen, to another program here on Legally Speaking. I do apologize for the rusty look. It's been a bit busy this past week. I have not gotten the chance to go to the barber just yet. So here I am looking a bit rusty, but here still to do part 3 in this 4-part series. In the first video we talked about intestacy, what that means. In last week's video we looked at deeds of gift, and we started looking at the benefits and the disadvantages of either a will or a deed of gift. I want to begin today's video by letting you guys know that my sponsor, Be Well Pharmacy, is now open. They opened last week and they are located directly opposite the Anglican Church. So if you are there on Grenfell Street, be sure to check them out. The newest pharmacy here in Kingstown, St. Vincent. Big them up. Thank you very much for sponsoring these videos. Now, this week we're going to be continuing our video from last week. So it stands to reason that if you have not looked at the video from last week, you should go back to that video and look at it. In fact, if you have not looked at the first 2 videos in this 4-part series, looking at those videos before you look at this one will help you to make sense of what we will be talking about in today's video. And there are certain things that I would mention in this video today and the video next week that, looking at all the videos that we have covered so far, would really help you to have a good understanding of what I'm going to be talking about, because we are essentially building on top of what we have been discussing so far. And so that said, welcome back, and I hope that this video today is beneficial to you in some way. In the first video that I did in this 4-part series, I was looking at intestacy, and I was making the point that if your, say, mother or father dies without making a will, you are going to have to present your birth certificate to show that that person was your mother or your father. And so in the absence of that certificate, you will not be able to prove that you should be included as a beneficiary under their estate without proving that relationship. When it comes to deeds of gift, in last week's video I mentioned that there are categories of persons who are exempt from paying stamp duty. In the same way, you have to present your birth certificate or your marriage certificate to prove that you are a beneficiary under the estate of someone who died intestate. It is the same way you are going to have to present a certificate to prove that you fall within the categories of persons who are exempt from paying stamp duty. Those categories again are grandparents to grandchildren, between spouses, between siblings, and parent to child. So if you want to, plan your estate using deed of gift as one of those instruments, you are going to have to present an original copy of that birth certificate or your marriage certificate or whatever the situation might be to prove that you fall within the category of persons who are exempt from paying that 10% value to the government, right? So let's keep that in mind. The same thing that applies under intestacy to prove status as a beneficiary, the same procedure must be followed in terms of proving the relationship if you wish to fall within the category of persons who are exempt from paying stamp duty. So as I mentioned in that first video in this 4-part series, I mentioned it here for the benefit of those who have not watched that video, that it's gonna be very important, for instance, for you to have your father's name on your birth certificate. So if your father is alive, let him add his name to your birth certificate so that you can benefit from the provisions of the Stamped Act amendment, right? So that's one. Number 2, in last week's video, I also mentioned the position of the common law partner, explaining that the intestacy laws do not recognize common law relationships. Now, the dynamics of that situation changes a bit if you have a child with your common law partner, a minor child specifically. That is not to say that if you have a child with your common law partner that you stand to benefit as a beneficiary under their estate, but if you have a child, a minor child with your common law spouse, you can apply to administer their estate for the benefit of your minor child, right? So even if you were never married, while that would disqualify you as being a beneficiary under your partner's estate, your minor child could benefit once you apply on their behalf. So that's going to be very important for you to keep in mind. Of course, if the child is already an adult, they can apply to administer the estate of their own parent. So I'm just letting you know that for the benefit of those who might not have understood that when I mentioned in last week's video the position of the common law partner. Right? But keep in mind, it's not for your personal benefit, it's for the benefit of the minor child, even if the proceeds of the estate fall within your hands. Right? So that's keeping that in mind. In last week's video, I mentioned one of the disadvantages of adding someone's name to a deed. And I want to mention here, when I spoke about deeds of gift last week, I mentioned transferring property entirely. Let's say I have a child and I want to give property to my child. I can do a deed of gift from Jamali John to my child, whatever that name is, to my child completely. There's another way that you can do it. You can add your child's name to your deed. So instead of transferring the property entirely from yourself to your child, you can add the child's name to your deed so that the both of you become the legal owners of the property. And I want to advise that this is one of the options that you want to look at, especially if you only have one property. This is important because there have been instances where parents transfer their property to their child, absolutely, and the child turns back to put their parent out of their house because they are now the legal owner of that property. That is something that you want to guard against very carefully, because you might figure that, my child would not do that to me. But the reality is, I don't know. It's very I don't even know how to explain that. Why a child would put a parent out of a house after a deed is executed in their favor. But it has happened. And so you want to ensure that it does not happen to you. And so one of the ways that you can avoid that, you can escape that, is to add their name to the deed so that the both of you are now joint owners. And in that situation, they would not be able to put you out because you are still co-owner. And you can also do it in a way that you create a life interest. So you can say, property to my son, Robert, with life interest. And you keep a life interest in the property so that you have that interest up to the point of your death and then to Robert. Right? So that is something that you really, really want to keep in mind. Of course, there are persons who own multiple properties, whether land alone or land and house, and so they don't have to be as careful. They could say, okay, well, I have 3 properties, one in Kittels, one in Bookament, one in Prospect, and I give my property in Bookament to my son. Absolutely fine. You live in Prospect, fine. But if you only have one property and that property is where you live, you want to be careful not to transfer property to your child, because you have to be aware of the reality that that child would now become the owner of that property, right? So you want to explore a life interest, or you want to explore simply adding their name to the deed. And as I mentioned in my very first video, there are 2 ways in which property can be held: tenants in common and joint tenancy. And joint tenancy here would help you to avoid some of the taxes and the time that we spoke about in last week's video. If you don't know what joint tenancy and tenancy in common, what those terms mean, the explanation you would find in the very, very first video that was uploaded to this channel on buying property. In that video, I explained, the two ways in which persons can hold property together, right? So you want to look at that. So now that you understand that, you want to keep in mind that even in circumstances where you simply add your child's name to the deed or your spouse's name to the deed, as co-owner, you would not be able to deal with that property at all without their permission and consent. So now you have two owners because somebody's name has been added to the deed. If you want to sell that property, the co-owner must sign along with you. If you want to mortgage that property or whatever you want to do with that property, just keep in mind that they would also have to sign. It's one of the disadvantages of doing a deed of gift, because either you completely lose the right to do anything with that property, or you have to act with somebody else whenever you have any transaction that you want to make relative to that property. A will does not restrict you in that way, because even if you have left that property to your child in your will, if you want to sell it, you can sell it. If you want to mortgage it, you can mortgage it. If you want to gift it to somebody else, you are free to do so, because that will does not take effect until the time of your death. So you want to keep that in mind. One of the things that applies to making a will and deeds of gift is that you have complete freedom to do as you wish. And so when you are making a will, you have what is called testamentary freedom. There's nothing that says if you have two children that you have to make provision for the both of them. You can dispossess, if I could use that word here loosely, one of your children. You could say, okay, I have two children, Robert and Mary. I'm going to leave everything to Robert in my will and forget about Mary. Same thing applies when it comes to deed of gift. If you have two children, there's nothing that says that you have to make provision for the both of them. If you wish to gift a property to Robert and not to Mary, you have that freedom. If you have two properties and say one is more valuable than the other one, you are free to gift property to whomever you wish, right? So you have that freedom. In the same way, you have the freedom when you are doing a will. And I want to mention here very, very quickly, whenever persons die without making a will and the estate is administered under the laws of intestacy, people oftentimes look at the nature of the relationship to challenge things. And so let's say my father had two children, right? And my sibling migrated, went away to Canada, US, and never looked back on my father. And I was the one who was with him all the time, taking care of him and so forth, and ensuring that he has stuff to eat, taking him to the doctor, covering his medical expenses, and so on and so forth. He passes away and he leaves a house behind. The law is very specific on how his estate is to be administered if he did not leave a will. The fact that I shared a closer relationship with my father does not make me any more entitled than the child who did not. Child might have even been estranged from the family. Doesn't really change anything. And so you want to keep this in mind. It also does not matter whether that sibling has property elsewhere. These are some of the remarks that people make, that this person wants the house but they don't have their own house somewhere else already. Those things don't really matter. So you want to keep this in mind, and remember to keep in mind that if it was not reduced to writing, whether by a deed of gift or a will, whatever was said word of mouth is of no relevance, it's of no importance, it is of no effect, right? So you want to keep that in mind. I'm repeating it again for your benefit, because it happens too often when people believe that those intentions, those spoken intentions that were not reduced to writing, should have some bearing in how the inheritance is shared. Now, there are two things that I want to mention very quickly in relation to there is a restriction on doing multiple deeds of gift for the same property within a 3-year period. So that's one thing that you want to keep in mind. And finally, you also want to keep in mind what I said in my very first video. If the property is mortgaged to the bank, when you go to your attorney to have that deed of gift prepared, you want to disclose to the attorney that this property that I wish to gift to my wife or to my child has been mortgaged to the bank. It's going to make a difference in how that deed is prepared. I have one more video for next week, Monday, that wraps up this entire series. We're going to be looking at the provisions of the Wills Act and what must be done in order for you to leave a valid will, and we'll also wrap up our discussion on deeds of gift. So I'll see you guys next week, same time, same place. Do enjoy the rest of your Monday evening and have a good rest of week.